All right, let's dive right in. Today, we're going to pull back the curtain on a really serious topic: credit card fraud in Arizona, specifically the law known as ARS 13 2105. But before we get into the nitty gritty, there's something we need to get out of the way first. Now, I have to be crystal clear about this. What we're talking about here is for educational purposes only. This is absolutely not a substitute for real legal advice from a qualified Arizona criminal defense attorney. So if you're facing charges, you need to be talking to an experienced lawyer right away. And look, it's totally understandable if you are. Facing any kind of fraud charge can be incredibly stressful and confusing. The legal system can feel like a maze. So our goal here today is to give you a roadmap to clear up some of that confusion and help you understand what this law is all about. Here's how we're going to do it. First, we'll define what credit card fraud actually is under the law. Then, we'll decode some of that legal jargon. After that, we'll look at the penalties, answer some frequently asked questions, and wrap it all up with the key takeaways. So let's get right to the heart of it. What does it actually mean to commit credit card fraud in the eyes of Arizona law? When you boil it all down, it comes down to one word: deception. The law kicks in anytime a person uses a credit card, or even just the card number, with the specific intent to deceive someone in order to get money, products, or services. Now, this is where the law gets really specific. To get a conviction, a prosecutor has to prove two things. First, they have to prove you had the intent to defraud. We'll talk more about that in a second. And second, they have to prove you did at least one of these three things: used a stolen or fake card, pretended you were the actual cardholder, or just made up a card that doesn't even exist. Okay, legal language can feel like it's from another planet sometimes. So let's break down two of the most important phrases in this law. Getting these definitions right is absolutely key to understanding the charge. So, intent to defraud. This is the big one. This isn't about making an honest mistake, like accidentally using your spouse's card thinking it was yours. To be guilty, the prosecution has to prove that you acted on purpose, with the specific goal of tricking someone to get something. It's all about what was going on in your head at the time. And this is a perfect example of how the law has tried to keep up with technology. When the law says credit card, it doesn't just mean that piece of plastic in your purse or wallet. Nope. It covers debit cards, gift cards, stored value cards, and crucially, it covers just the card numbers themselves, like when you type them into a website. All right, let's talk about what's at stake. The penalties for credit card fraud are no joke, and they pretty much all boil down to one single factor: the dollar value of whatever was taken. The magic number here is $250. If the total value taken over a 6-month period is less than that, you're looking at a misdemeanor. But the second you cross that $250 line, boom, it becomes a much more serious felony. And that 6-month window is really interesting. It's there so that a bunch of small, separate thefts can be added up to show a bigger pattern of fraud. This chart lays it all out pretty clearly. You can see anything under $250 is a Class 1 misdemeanor, which could mean up to 6 months in jail. Once you're between $250 and $999, it's a Class 6 felony. And if the value hits $1,000 or more, that's a Class 5 felony, carrying a potential prison sentence of up to 2.5 years. Okay, that was a lot of legal detail. Let's switch gears and run through some of the most common questions people have about this law. Kind of like a quick Q&A session. First one up. We touched on this, but it's so important it's worth asking again. Is this law just about the physical piece of plastic? And the answer is a hard no. The law is very, very clear. Using just the number online with the intent to cheat someone is treated exactly the same as if you had the physical card in your hand. Here's another one that trips people up. What if the transaction gets declined? You try to buy something, but it doesn't go through. If you didn't actually get anything, can you still get in trouble? Yes, 100% yes. The law was written to cover not just getting away with something, but also trying to get away with it. So just because the purchase was declined, that doesn't mean you're in the clear. The attempt itself can be the crime. And what about the clock? Can the state just wait around forever to charge someone? This gets into something called the statute of limitations. Yep, there's definitely a time limit. The state doesn't have forever. For misdemeanors, they have just 1 year from when it happened to file charges. But for felonies, that window's way bigger. They've got 7 years. Phew, we have covered a ton of ground. So let's bring it all home and focus on the absolute most important things you need to remember from all this. So if you forget everything else, just remember these 4 points. Number 1, intent is the whole ballgame. Number 2, the value of what was taken is what separates a misdemeanor from a felony, and $250 is that dividing line. Number 3, the law defines credit card very broadly, and it includes failed attempts. And number 4, there are strict deadlines for the state to act. And this quote right here really sums it all up. As you've hopefully seen, these are not simple charges. There are a lot of moving parts, the details matter, and the potential consequences are huge. This is not something you want to face by yourself. So, we've taken apart the law, we've defined the terms, and we've looked at the stakes. Having this knowledge is a powerful first step, and that leaves one last question. What's your next move? For anyone actually in this situation, that next move should be pretty clear. Talk to an experienced legal professional who knows this stuff inside and out. Thanks for joining us for this explainer.